Okay, everybody. Jason Parker here. It is 4 o'clock, and John, can you hear me okay?
Can you
Okay.
hear me now?
All right, there you are. Okay. Can you hear me, John?
I can.
Okay, so I'm going to go ahead and do a quick introduction, tell everybody we're going to get started. Jason Parker here, everybody. Thanks for being on the program. Most of you I have the pleasure of knowing. We get to work together in some capacity here, and in most instances, it either means I'm your financial advisor, or I manage money for you in the stock market, or I've helped you with insurance or retirement planning in some capacity. Other people today are on the program because maybe they've read Sound Retirement Planning, the book, or they listen to the radio show, Sound Retirement Radio. Anyway, you slice it, I just want to thank you all for being here. You know, one of the things that we are committed to is always trying to add significant, meaningful value to the people's lives that we serve right here in Kitsap County, and with the success of the book and the radio show, really with people all over the country. I want to remind everybody, this is a quick look at soundretirementplanning.com, the website. And just remind everybody that we are always archiving content here. I'm always writing new information based on what's happening around the country. We're bringing expert guests onto the radio show that you can listen to and plug into some of these resources. So one of my beliefs is that when you have good information, you're going to feel better about the decisions you're making, and you're going to live with a greater sense of confidence. And when you have that confidence, ultimately, my hope is you experience a greater sense of freedom. Freedom to go out and really do the things you want to do and be with the people you want to be with, and not have to worry about some of this stuff. And so that's why we work hard in our community and across the country today to help provide that for you. I've got a great speaker presenter on the program today. I'm going to be introducing John Kenney. Many of you know John, either locally here in Kitsap County, or if you've read my book, you've read the chapter on estate planning where I interviewed John, and he provides just a wealth of information and knowledge. Estate planning, I found, is one of those areas that it's critical that we get this right. And sometimes people will ask about low cost, picking up forms at your local office store to get your estate documents done. And I think there's times when you should try to save money on advice, and then there's times when it really pays to get good advice. And there have been instances, a good friend of mine recently ran into a situation where his dad decided not to get the proper forms done by somebody that knew what they were doing, and ended up causing a lot more grief for their estate than would have otherwise experienced if they had just spent a little bit of money up front to get it done right. So I want to encourage all of you, when it comes to your estate planning, and when it comes to your taxes, when it comes to your investment management, there's places to cut costs, and there's also places where you don't want to be a penny pincher. That being said, today's presentation is completely complimentary. This is free. This is just one way that we try to add value to your life. And John Kenney's he's going to be my presenter and speaker. There's only 2 people here locally that I feel confident to be able to refer folks to when it comes to estate planning issues, and John is one of them. One of the things I think that really makes him unique in our community is he went back to school for a couple of years to get a master's in taxation. So when we're working with higher net worth folks and people that have more complex estate planning issues, John is really my go-to guy. So with that being said, John, I don't want to eat up all of your time, but thank you for taking time out of your busy schedule here to be a guest presenter.
Thank you, Jason. Just a couple of technical details real quick. I need to be able to share my screen. Jason, I don't know if you can give me the control to do that. I also want to apologize to everybody in advance. I have a cold that I've been fighting, and so my voice and my throat, I'm a little nasally, so I apologize in advance. I'm usually not speaking like this. Jason, if you could check my screen, I want to make sure which view you guys are seeing out there of the slides that I have.
Yeah, I see a blue slide here, fundamentals of estate planning, wealth preservation, and transfer.
Okay, great, perfect. So basically, just to add on to what Jason just said, I have a master's in tax law, and so that is an advanced law degree. and I've been doing estate planning now for almost 18 years, about 18 years, and I practice primarily here in Kitsap County, but also all over the Seattle area as well as in other states around the country, depending on who's calling and who needs the work. But one of the things I really enjoy most about working with my clients is to help my clients understand the value of estate planning, and I also enjoy teaching seminars. I probably average about 3 to 5, sometimes 6 or more seminars or webinars per year, and I always tweak my slides, and in fact a couple hours ago I tweaked these slides a little bit, and so hopefully everybody who's on this call will get some value out of this. And there is, I'm not sure what everyone's screen view is, but there is the capability, if you can figure it out, to ask questions. What I'll try to do is answer any questions if they come up. If I'm in a particular area and if it's about that area, I'll answer them, but if it's not, if it's unrelated, we'll probably just wait until the end and defer questions until the end to answer questions that are sort of unrelated to what I'm speaking about at the moment, just to not get off topic too much. So my office is in Poulsbo, Washington, but as I said, I practice all over the area and all over the country. One of the things that people wish to do when they think about estate planning is to basically control their wealth and be able to avoid costs. I mean, that's the thing I hear most is I don't want to spend more than I need to in taxes or pay attorneys ridiculous amounts of money. And in some states, the costs can be ridiculous. California is notorious for their estate and probate costs as well as taxes. And so what I try to do is just educate clients on the total costs and potential problems that they may face, and help them understand with estate planning you can avoid a lot of costs and estate taxes. So here's the slide I threw in today. I've actually written an article that's much more comprehensive than this one slide with these bullet points, but these are a lot of the common things I run across. I heard that my spouse will get my property if I die without a will. Well, that's not exactly true. There are some state laws here in the state of Washington, because of community property laws, that your spouse will probably get most of your property if you die without a will, but it's not always necessarily the case. I'm dealing with a case right now where an individual was married, and they were married a very short time, and then the husband passed away, and unfortunately the property, the real estate that the husband owned, had not been transferred and jointly titled in the name of the husband and the new wife, and of course she's got little to no claim on that real estate. So, and he died without a will. So it can get complicated if you just assume that your surviving spouse will get everything that you own. Even if you've been married a long time, that's not always the case. Leaving or having a will, but believing sometimes incorrectly that you won't owe any estate taxes. I'll talk later about the estate tax system here in Washington, but suffice it to say that we do have an estate tax here in Washington, which can occur on either the first spouse or the second spouse's death, and it's actually a lot lower than people believe. So we'll talk about that in a moment. Another thing people try to do is they try to gift their children their property. So whether it's real estate or stocks or bonds or mutual funds or anything like that, and that may seem on the surface like a very smart way to do things, so you can sort of avoid any problems after you're deceased and your kids just own everything. But in recent years, with the appreciated values going up of real estate, and then they're starting to go back up again, as well as any appreciated stocks or other investments, you can really do a disservice from an income tax perspective by gifting some of your appreciated assets while you're alive rather than holding them until you're deceased. So this is one I often see where people just don't think it through correctly and don't talk to the advisors, an accountant and an attorney to really talk about what are the alternatives to just giving away property while you're alive. So that's something that's really important to consider. Life insurance. We'll talk later a little bit about life insurance, but suffice it to say that life insurance, one of the biggest misperceptions about life insurance is that it avoids estate taxes, and this is not true. In fact, I have a lot of clients that the sole reason they will pay estate taxes is because they have a large life insurance policy, and it's the existence of that policy that will cause them to pay estate taxes. So if you have life insurance, don't go under this sort of incorrect assumption that it's going to avoid estate taxes. It will not typically. So there's ways to plan around that. We'll talk about that briefly later. My kids know what I want done with my stuff. This is one I hear all the time, particularly when it relates to personal property items like cars and boats and stuff in your house. I tell you, if I had $1 for every dispute I've seen over silly things like guns and jewelry and cars, I'd be a rich man. It's something that a lot of people take for granted, that their kids will get along after they're deceased and that they'll happily divide everything up without any disputes, and it's almost the opposite when I've been involved in the cases where clients or people fail to plan for personal property items in particular, and so that's something to consider. This one here, Jason mentioned this before, used to be that you can go down to Office Max or Office Depot or Staples and get a form to do a will. Now the internet is the new place to go, and anybody who has Google and knows how to use it can find a will format. This is a big problem because in most states there's formal rules that are required for someone to do a will. I've seen wills of all different sizes and shapes, and there's just a lot of problems with do-it-yourself wills that people don't know about, and so that's going to be something you have to be concerned about. Another common myth here is that if somebody becomes incapacitated, this means that your health has reached a point that you're no longer able to manage your own personal affairs, that your spouse can easily just start doing things for you. This is partially true, particularly when your spouse and you are on joint bank accounts. The spouse can certainly start doing excuse me, some of the banking things if their name's on the account, but it's not always true if there's other things that need to be done with your life, and so oftentimes a guardianship process is required, and we'll talk about that in a little bit too. The last bullet point that I see here that's sort of related to Washington state estate taxes is the myth that if you have less than $5 million of wealth that you won't pay an estate tax, and this is not true. $5 million is sort of the rule of thumb for the federal, the IRS estate tax, but the estate tax here in Washington, unbeknownst to many folks, starts at $2 million. We'll talk about this briefly later on, but if a lot of you out there saying, oh, I didn't know that, it's because it's not very well publicized and there's not a lot written about it or talked about it. But if you have value in real estate, investments, and life insurance that exceeds $2 million, you may have a taxable estate, which means it means that you're going to potentially pay a tax upon your death. So we'll talk about that in a moment too. So statistically, there's all sorts of studies. There's anywhere between 50 and 60% of Americans don't have a will. 50 to 60 don't have a living will. We'll talk about those in a bit. And excuse me, my throat's getting dry. 62% don't have a healthcare power of attorney. We'll talk about all this. It's just a statistic that's kind of there to show you that a lot of people aren't doing this type of planning, and certainly most of you on this call, because you are on this call for a reason, have probably done some type of planning. So I would imagine that the statistics on this call aren't the same exact numbers. There's probably a higher percentage of folks who've done their planning, but certainly something to think about.
John, it's funny to me is that we find a lot of people don't get their estate documents, their will, power of attorney, living will, all those documents updated until they're getting ready to travel and go on vacation. And then all of a sudden it becomes a priority, and it seems like people want to get it done yesterday, but the travel industry seems to spur a lot of the folks we serve into getting some of this stuff completed and updated. John, I just wanted to say thanks again. I know you're not feeling great, so I appreciate you fighting through this sore throat and scratchy voice that you have. And also,
I apologize.
No, that's okay. For our listeners, though, too, over here on the right-hand side, there's this little chat box. So as we go, if there's any questions you have that you'd like us to try to answer at the end of the program, be sure to go ahead and just write those as we go, and we'll be sure to try to get to them. But sorry, John, go ahead.
That's okay. Thanks, Jason. I got a little break to drink some water. So one of the things, as Jason said, the other thing I'd like to mention is that, a lot of people have wills, but it's so common to see people with a will that's 20 or 30 years old, and life has changed, the laws have changed, and I recommend that if you haven't had your will updated or reviewed in the last decade, it's time to do that. The laws have changed substantially, both the estate tax laws and federal health care laws that will really affect the older documents that you have. So I have a few fun slides in my presentation just to go through some really interesting facts that people don't know about. These people, of course, are celebrities or people that are well known or well-known families, and it's just a magnification of what's going on in society. I mean, it really is true that people forget to do planning. James Dean didn't have a will. Everything he owned when he died, mostly what's continuing to generate income for his family are the royalties and licensing fees from his image and his films and those sort of things. He died, and his dad had left and abandoned him when he was a child, and his mom had already died, and so his dad got everything. And kind of a sad scenario, but there's nothing you can do about that. So kind of there's a slide later on about the state having a plan for you if you don't have a plan, and that's what happened in his case. His dad got everything. So Marilyn Monroe, everyone knows who Marilyn Monroe is. You know, she made a lot of money during her lifetime, and gee, how many of us have seen images and continue to see images of Marilyn Monroe and her famous photos? Those images, every time they're shown or used, pay somebody a royalty. Well, she left a will that said her agent or her acting coach, excuse me, was to get everything that she owned or get 75% of everything she owned, and she wanted them to go to charity. Well, guess what? The agent got it, and he kept everything and ended up giving it to one of his wives, and Marilyn Monroe had certainly no intention of giving that wealth to that wife. Now that former wife of her acting coach and her family and all the other people that have succeeded her in life are getting a lot of royalties, and as the slide says, her royalties have generated about $30 million over the past many years. This one's an interesting one. Those of us who are old enough to remember, I'm much older than my photo looks, remember the Woolworth stores. Woolworth was sort of a drugstore slash department store that's been around in the early part of the century, and I think they died out in the 80s. But I remember Woolworths as a kid. This woman who's on the screen here was one of the heirs of the Woolworths fortune. She was a grandchild of the original Woolworth founder. And at age 10, she inherited $25 million. Now, that was a lot of money. That was like in the 1920s, I think. And then at age 31, or excuse me, age 21, that money had been kept in a trust and it was distributed out to her at age 21, which is a pretty young age by today's standards, and it was $50 million. Well, guess what happened, of course? She was 21, she got $50 million. That was 1933. Can you imagine what kind of money that would be in today's dollars? As you can see here, 46 years later and 7 husbands later, she died almost penniless. And again, this is the type of stuff that can happen if you leave a lot of money to children and you don't have some sort of controls or other things on the money to be able to protect them from themselves, spouses, addictive behavior, that sort of thing. Who out there doesn't remember John Denver? John was a great singer. Wasn't a superstar, but he had some really cool songs that were easy to sing along to and a very pleasant voice. I think he even tried his hand at acting. Well, anybody who's old enough can remember that he was killed in he had this like light plane, ultralight plane or something, was killed tragically. And what a lot of people don't know is he had a large estate, about $19 million. And a lot of it was tied up in pension funds. Well, John forgot or failed to name a beneficiary of his retirement and pension funds, and Jason will tell all you that that's a really fatal flaw for someone who has a big retirement account or pension. And so as a result, the IRS got a bunch of extra money, and the cost to go through probate just really devastated that amount of money. And so it, not to mention the compounding of that retirement plan had it passed to his children, and they had been able to stretch it based on their life expectancy. So I'm going to jump off with the examples now and talk about guardianship. I mentioned earlier that a lot of people believe that their spouse can take care of everything for them, which is the case much of the time. If you're single, forget about it. You will have to have a guardian appointed by a court. And that is the process, the standard process, if someone becomes incapacitated, which nowadays, I don't have any statistics in front of me, but many of my clients, before they pass away, actually go through a period of a dementia or some amount of mental diminished capacity. And I think anybody who's old enough to have parents or other family members who've gone through this will also recognize that that is the case, that it does happen in a lot of cases. Guardianship, as the slide says, this is from the Minnesota Attorney General's office, can be all these things: expensive, time-consuming, and in fact is unnecessary if you do, if you can do the right documents. A power of attorney, a good power of attorney, is one way to avoid a guardianship, and these powers of attorney are often called durable powers of attorney, and the reason they're durable or called durable is because they can actually endure through somebody's incapacity, so they can go on potentially forever. Most powers of attorney that are not these types will expire after a certain period of time, like a year or 2 years. And so it's important that you have a good, durable power of attorney that will cover everything that you need covered and is comprehensive for your spouse or other family members to manage your affairs for you. One of the things I see very commonly is that, again, people get their power of attorney from a software program or the internet or Office Max or Office Depot. But, you know, again, it's very dangerous. Powers of attorney, once someone becomes incapacitated, they cannot be changed. And so if you have a bad power of attorney that doesn't have all the right magic language in it or isn't as comprehensive as you need it to be, you'll end up in court anyway going through a guardianship because the power of attorney just fails you. And so that's important that you work with somebody, a good attorney, to get a good durable power of attorney. Another way to avoid a guardianship is to use a trust. Now, I'm not going to talk right now about trusts in detail. I will in a few moments when we get to that. But a trust is a common way to avoid guardianship. And so between a trust and a good durable power of attorney, one can do this and avoid those costs. A trust is basically like a corporation. It's an artificial person that sort of substitutes for you or your spouse or both, and then you run it, you control it, and like I said, we'll talk about those details in just a moment here. So let's shift gears and talk about probate. We talked about a guardianship, which is sort of a process that can occur while someone is alive and somehow has this diminished capacity or incapacity, where the judge will have to decide who is going to manage that person's life. A probate is a process which happens only after someone is deceased, so it doesn't happen while someone's alive. They're sort of counterparts to one another, and so a probate process is a process that is not always necessary, but if you have no will, it's absolutely necessary. Well, I shouldn't say absolutely. In most cases, it's absolutely necessary. There are certain exceptions. And if you do have a will, it's usually necessary in most cases with certain exceptions. But the probate process in every state, it differs. It's very different from state to state. I get a lot of clients who move here from California, and California, as I said earlier, has a terrible state as far as costs and taxes and length of duration of probate. And so a lot of people have this sort of fear of the probate process. And so in Washington, thankfully, the process isn't that terrible, but nonetheless, here's some of the key features of probate. It's a process where your ultimate distribution of your property, and I use property in the legal sense, which means everything that you own: bank accounts, cars, boats, household goods, real estate, rather than the real estate context, which is what a lot of people think property is. In the legal world, when we talk about property, it's pretty much everything that you own. But the court will supervise the distribution of your property to the people that you've said in your will, or, as I said earlier, if you don't have a will, the state has a law that says how your property will be divided. It's public process. The purpose of the public process is to put a notice in the newspaper and invite people who may want to make a claim, whether it's long-lost children or creditors who believe that you owe them money. And those people can show up and literally make a claim against your estate, whether or not it's valid or not. That can certainly cause a lot more cost to the process than is necessary if you don't plan for it. As I said, it's public record. That means anybody can go into the court and pull out your documents, pull out records of your financial dealings, because your investments, your real estate, everything will be in that file and open for inspection by anybody who wants to come and stick their nose in it. It can be expensive, it can be complex, but not always. The other thing that's really important is that if you own property in other states, a probate will be necessary in every state that you own real estate. I've actually seen probates have to occur for timeshares in other states, where you don't think of a timeshare necessarily all the time as real estate, because sometimes you just go there a week or two a year and it seems like a vacation, but in some states it's deeded. It's actually a deeded property right, and you're required to go through the probate process. So again, a lot of little things to consider when looking at all this in sort of the big picture and talking over with your advisors, because if you have real estate in other states like California, Arizona, and you're a snowbird, like many of my clients are, and they go down there to stay for the winter months or a couple months during the winter, that can be pretty expensive to have to do a probate in both Washington and the other states. So something to consider with a probate. I mentioned earlier the estate taxes. Now this is a busy slide. I'm just going to focus on a couple things. The federal government has a credit. It's called the applicable exclusion amount, but we also call it a credit, but it's easier to understand. You can see there kind of the historical credit for the federal government. It's gone up since 2001, and it's pretty good credit right now. It's about 5.4 million in 2015. But as I said earlier, the key that we have to watch out for in Washington is that our credit in Washington is just over $2 million. So that can cause a lot of problems for my clients who have net worth between the $2 and $5 million range, who believe they're kind of home free for estate taxes, but in reality they aren't, because anything over $2,054,000 is taxable in Washington. On the right side, you see the maximum top rates. As you see there, it's 40% for federal government and 10 to 20% for the state of Washington. So you could have a scenario if you have more than excuse me, 11 or 12 million dollars, where you could be paying 50-60% in the state tax. So that's something to watch out for. And there's a lot of other advanced planning techniques we can use to sort of avoid estate taxes on those larger estates. So let's talk about some of the basic estate planning documents. A last will and testament. This is something that everybody should have. I don't care if you're rich or poor. Everybody should have a basic will. Now, depending on your personal situation, your goals, your concerns, you may need something different or something else in addition to a last will or a basic will. But it's a document that's most commonly used to handle the distribution of your property after you're deceased. The other thing that a will do is if you have minor kids, minor children, it will designate guardians. It also designates the individual who you determined should be able to manage your affairs after you're deceased. One thing about a will is once you're deceased, it's set in stone, so you can't really change it, obviously, after you're dead. Here's some potential problems. It's not a document that can have any effect on a guardianship process like a trust. I mentioned trusts briefly earlier. We'll talk about them in more detail here in a moment. The wills don't always control all of your property. Sometimes they don't. And the most important thing, I think, is that if you have multi-state properties, the will just does not do a good job of effectively avoiding all the costs you want to avoid in probates in another state. It doesn't provide for disability, and it does not avoid probate in most cases. So a lot of people believe that if they have a will, they don't have to go through the probate process. That's not true. You may avoid probate if you're married and the will says certain things, and depending on how your property is titled, but it may not avoid probate at all. So it's important to figure out if it will avoid probate. As I said, probate's not a terrible process, but certainly avoiding it is sometimes desirable for folks. It's not the best to avoid estate taxes. And I say this for folks who have a net worth of over $2 million. It's perfectly adequate to avoid estate taxes for folks who have a net worth under $2 million. And finally, privacy is lost. It can become a public document. Here's an actual document that my partner years ago pulled out from Pierce County. And what it does not show here is that the person whose will this is, the children's names were listed there, and then it also listed Social Security numbers later on. I've actually seen this document, and the Social Securities are right there, numbers are right there. Now, thankfully, attorneys started getting smart in the 70s and 80s when they realized that putting Social Security numbers in these documents that were public was not such a good idea. So most of the time, we don't see these types of documents with Social Security numbers in them, but they do exist down there in the county courthouse records. So I talked about a trust earlier. A trust is sort of an alternate type of will. It's not a will, but it's a document. Like I said, it's like a corporation. It has its own life, its own existence. The people that create the trust are the ones who control it typically. There's a lot of different types of trusts that do a lot of different things. Most of the creative and sort of fancy types of trusts are used for other advanced estate planning. The most common type of trust that is used for basic estate planning is called a revocable living trust. And I would venture to guess that some of you out there may already have a revocable living trust, or have heard of them at least, or dealt with them. And so it's becoming more and more common for people, primarily as a probate avoidance tool. We'll talk about that in just a moment. As I said, the person who creates it is the trust maker. They have control of it. They are the beneficiaries of the trust, which means that they are entitled to use the money or the wealth or the investments that are in the trust. And then if somebody becomes disabled, that means that the trust has provisions in order to avoid the court process of guardianship, so that all the contingencies are met within the trust, and the people you've named as successors, whether it's a surviving spouse or the healthy spouse in the case of a disability, or adult children or other close family friends or advisors, can be named as successors to take over. Some of the features of a revocable living trust are listed here on this slide. It's a substitute. It's easy to change. The person who creates it retains control. One of the questions I get asked quite a bit is what's the tax consequence of having a trust like this? For IRS purposes and income tax purposes, the IRS considers these types of trusts invisible. In other words, they do not exist. And so they're tax neutral from a tax perspective, and so they won't cause any more income tax or any less income tax to be paid by the individuals who own it. Trusts are private. They don't have to be registered in the court. They don't have to be open to the public. They don't have to be shared with anybody other than the people who are the trustees or the beneficiaries of them after you're deceased. They're not that difficult to create. They're not difficult to maintain. It'll avoid the probate process. This is something that a lot of people desire, whether they're living in California or whether or not they've been through a probate with a parent or family member and they desire to avoid probate. The transitions with the trust are pretty smooth. There is some work required after someone is deceased, but it's not as much as going through the probate process. The other thing that's great about trusts is they are operative in all 50 states. So what frequently happens with my clients with multi-state properties is we will put all their properties in a trust, thus avoiding a probate in all states where they have real estate. I have a client right now I'm doing work for who has real estate in Montana, real estate in Washington, and mineral rights for oil and natural gas up in North Dakota, which is a pretty great investment right now. And so we're now transferring all that to their trust that we just created. There's a lot more estate tax flexibility with the trust. Without getting into the details, we can be a lot more creative to avoid estate taxes. And also, I'm going to skip over the second to last bullet, but asset protection for the surviving spouse and heirs potentially. So let's talk about that. One of the things I've seen in my lifetime now as an attorney practicing is I've seen a very common thing where when a client is older, particularly it's with the older folks, and they die, and their surviving spouse becomes lonely, and they want to get married, remarried. And what happens sometimes is that that surviving spouse can be influenced by the new spouse, and I've actually worked on a case where the surviving spouse changed the original will and gave everything to the new spouse and disinherited his own children. In other words, they felt that the kids, this husband who had remarried after his wife had died, felt that his kids didn't need anything from his will because his wife was younger and didn't have any money, and he gave everything to the new wife, and the kids got nothing. So you can actually write a trust to build in mechanisms so the surviving spouse cannot do that, or they can only do it with a portion of the trust monies, not all of them. So that's something that's important to a lot of folks. Another one that I see very commonly is where a surviving spouse remarries, and guess what? They get divorced a few years later. Those are common cases where if they commingle their assets, and this is more of a divorce law case, but if they commingle their assets, the new spouse, the one that the surviving spouse was remarried to, can make claims on this wealth that the original married couple had accumulated during their lifetime. So that can happen. So a trust, again, can protect these things. We talked about the Woolworth woman earlier who inherited a bunch of money. I think it was $50 million at age 21 in Washington State. If you don't have a trust, then a child or grandchild or whoever you're leaving your money to will automatically get that money when they're age 18. So again, another reason to consider sort of managing a child's inheritance in a trust for a period of time. Usually 30 or 35 is kind of the recommended age so that people, your kids and grandkids, can kind of get through their first marriage and get through college and try to figure out what they're doing with their life before they actually spend all their money. People have kids that are bad money managers. It happens all the time. People have kids who have substance abuse issues. People have children who may have a rocky marriage. Creditor issues. Sometimes people come in and tell me that their kids had a business and the business went belly up and they owe a bunch of creditors. So all of these reasons on the left are good reasons to consider having a trust because, again, with a well-written trust, you can avoid creditor problems, your kids getting divorced, your kids getting too much money to blow it on things or drugs or things like that. And every client situation is different. And so we actually have a worksheet that goes through a lot of these concerns, and sometimes clients have the perfect children, and none of these are concerns. And just everyone's different, so it's important to think about these things and talk about them with your estate planning attorney. So let's shift gears. We talked earlier about how 50 to 60% of folks don't have a living will or a healthcare power of attorney. Statistically, 85% of deaths now are occurring in hospitals or some other sort of long-term care facility. What that means is people are living longer. Now, they may not necessarily have their brains or their wits about them, but they're living longer and they need documents to help their family or enable their family to manage their health care. A living will is a document that basically says that you don't want to stay alive on machines and be kept alive by machines, and that sort of avoids unnecessary costs of that sort of care, like the intensive care that you get when you're on those sort of machines. It also, or with a healthcare power of attorney, you can also designate the person who has that power and authority to make those decisions about when life support will be removed. It can also be much broader, which is typically the case with a healthcare power of attorney, where that agent can, you just may had a bump, you may have had a bump on the head, but you need emergency surgery, and your agent can actually use that healthcare power of attorney to authorize your emergency surgery, and then you'll be fine, and then you don't need the document anymore. But most commonly, these documents are used sort of at the end of life when someone has sort of lost their capacity to make their own healthcare decisions. Here are some of the problems with healthcare decisions. It's been a few years now, but I'm sure everybody remembers that Terry Schiavo case from Florida. It was a pretty famous case because you had Governor Jeb Bush getting involved, Jesse Jackson getting involved, probably Al Sharpton was somewhere on the scene. I mean, you name it, the people were getting involved. The U.S., I think the Congress did an inquiry at some point too. I mean, excuse me. it was just sort of a mess. Now that was an over-exaggeration. I mean, reality is that situations like that typically don't happen. However, I have seen situations where if someone doesn't have the proper documents, it takes a few weeks before the family members can kind of come to a consensus about removing life support. And I've actually had clients tell me that their parents who didn't have a document and lingered a little longer in intensive care, that care costs an extra $50, $75, $100,000 because of the lack of a document to enable people to make decisions quickly once they decided that they're going to let that person go. So it's important. It's important, I think, that everyone at least thinks about it and makes a decision to have these documents, because ultimately, if you are avoiding the documents because of denial or something like that, it's your spouse who's going to pay those bills, or your kids who will pay those bills. And then again, there's a lot of emotional sort of trauma and strife that goes along with this sort of time in someone's life. It's not an easy time to go through. So again, I mentioned these earlier. A living will is a common document that states your wishes and desires, and a healthcare power of attorney designates the individuals who are going to make those decisions for you. So those are two important documents. So we're getting near the end, but kind of a summary here. A comprehensive estate plan that we commonly do for most of our clients is going to include several documents. It's going to include a will, a basic will, or in substitute for a basic will, we'll include a revocable living trust and a very simplified will. Without getting into the details, a will is still necessary when you have a revocable living trust. It just won't do as much as a normal basic will do. I mentioned earlier a durable power of attorney, so everybody's estate plan should include that. And finally, the healthcare documents that we just finished discussing, the healthcare power of attorney and a living will. So these are commonly the 4 or 5 documents that are included in an estate plan, comprehensive estate plan. Just a couple of other things. I mentioned earlier that life insurance can be included in someone's net worth for estate tax purposes. And one way that we can easily avoid this is through an irrevocable life insurance trust. It's a very easy trust to set up in the right situation, and basically the net effect is it takes the whole death benefit of that life insurance off the table for tax purposes, and that can be a great thing when you consider a lot of people have big policies, $500, $1 million, sometimes $2 million policies, that the sole reason there'll be a tax for estate tax purposes will be because of that policy. So it's important to consider. We often do things called family limited partnerships for transferring wealth to younger generations, children and grandchildren, and then gifting of your assets to family, friends, and charities. Again, as I mentioned earlier, it's important to talk about this with your advisors so you gift the right types of gifts that aren't highly appreciated assets to family and friends. To charities, it doesn't matter so much, but that's something that some people want to consider. Charitable planning, I have a lot of clients who are charitably inclined and want to leave something, whether it's during their lifetime or at their death, to charities. I set up quite a few charitable trusts and charitable foundations for folks who have that extra wealth beyond what they need to leave to their kids and want to kind of do something special with it. And so a lot of people will consider that. Retirement plan trust, we don't really get into this in this presentation, but a lot of people have large IRAs or 401ks, and there are ways to control that and avoid estate and income tax on those potentially, where you avoid the problems that John Denver had, and certainly at the very minimum working with someone like Jason to make sure your beneficiary designations are correct. And then again, every situation is different, but sometimes people want to control their retirement plans a little more than just leaving it to a spouse or kids or grandkids directly. Excuse me. Again, there's a lot of different things we do in estate planning that are more advanced. I'm not going to get into them here, but certainly you've got an idea of what the basics are. Now I can pause for a second.
All right.
Let my throat recover a little bit. Hopefully we have some good questions that we can answer, because we covered a lot in a short amount of time. So let's try to get some questions answered. Anything
Absolutely.
out there?
Yeah, John, first of all, I just want to say thank you. Again, I know that you're a little under the weather, and so I really appreciate you taking time to be here and share your knowledge and expertise with our community, our listeners, the people that have read the book, and just people right here in Kitsap County. So I do have a couple of questions for you. One of the first ones is, there's people are reluctant, I think, oftentimes to go get legal advice because, well, frankly, sometimes attorneys don't have a great reputation, and there's not always a lot of transparency when it comes to how much it's going to cost somebody to get some of these documents done. So if somebody's looking to go get a revocable living trust, how much money should they be prepared? What do you think is a ballpark or a range of that somebody should expect to pay for that type of a document?
Sure. Well, it depends on if they're working with someone in Seattle at a Seattle law firm or Kitsap County. That's kind of one of the big factors when you ask that question. When clients come to me, whether they're just getting a basic evaluation, our evaluations and sort of initial meetings are complimentary. Excuse me, and we do all of our work, whether it's a package that includes a will and all those other documents, or a revocable living trust that includes a trust and all those documents. We do everything on a flat fee, and so what that means is, after that first meeting, or if a situation is more complex, after another meeting or two, we can tell the client what it will cost. But on average, if someone is doing a revocable trust package, which includes all those other documents, and they're a married couple, if they're going to go to Seattle to a law firm there, it might be $3,000 to $6,000. Here in Kitsap County, no one should pay more than $2,000 to $3,000 for that same type of service. So again, it varies with every client because some people have very straightforward situations, some people have very complex situations. So it really just varies. But that's kind of the range of what I've seen with the work I've done.
So, John, one of the questions about that, is there a top end? Because, I've seen here locally where people have paid $15,000 to get state documents done by one attorney, and I've seen another attorney do those exact same documents for somebody for $3,000. So, is there a point where you just start asking yourself, okay, this seems a little bit expensive, a little bit too ridiculous?
Well,
Is that
if someone
regulated
is
in any way? Does anybody regulate how?
yeah, nobody's regulating this. I mean, I have seen clients who have gone to certain unnamed attorneys who do a lot of marketing on the radio, pay ridiculous amounts of money for something I would do for a fraction of the cost. So it depends on the attorney, but for the basic stuff, nobody should be paying more than $4,000 or $5,000 locally. I mean, I can imagine scenarios where there's a lot of extra work that goes beyond a revocable living trust where they may be paying $15,000, but that's work that's beyond a revocable living trust. I mean, whoever's charging that's doing a lot of other work, or they should be doing a lot of other work.
Okay. Now, another great question came in. What should people be thinking about if they have heirs outside of the United States? So if they have family that lives in Canada, what kind of complications does that create for them?
Well, it doesn't typically create complications for the folks here or the people you have handling everything. It can create complications if you're naming those people as trustees or personal representatives in your will because, practically speaking, it may be hard for them to come down here and deal with the stuff they need to deal with. But you can leave wealth to anybody in the world. I think the key is how much of it, is you're leaving to them because we have laws in the state or excuse me, the IRS has laws that if you're leaving money to a non-citizen spouse, for example, you have to have a special kind of trust, kind of an extra trust written into your original trust. So it gets a little complicated with non-citizen spouses, but for other family members, if you're leaving something to them, typically there are no restrictions. Now, they may have to consult an attorney or a tax professional in the country they live in to see what they will have to pay to their government after receiving this wealth, but there shouldn't be any extra costs or problems with you leaving wealth to your family members out of the country.
Okay. Another great question I have here for you, and I'll ask this in two parts. The first one is, if you'll just quickly kind of give an overview of what a special needs trust is the first part of the question. And the second part of the question is, do you help people with that kind of trust work?
So I'll answer the second part. Yes, I do help people with that. A special needs trust is basically In our state and in almost all states, there is a program, the most common program for people who have disabilities is Medicaid, where they get kind of some health care. There are a lot of other government programs where people get some amount of aid or training or something like that. And many of these programs, whether it's a federal program or a state program, are based on someone's need. So in other words, you have to have a low income or a low asset and income in order to qualify. And so what we see frequently is an individual, whether it's a child, a grandchild, or somebody else you're leaving money to, who has a disability of some sort, and they may be on government programs or in the future may apply for some government programs. And by leaving them money, number one, if they've got some sort of disability and they can't manage money because of this disability, that's kind of a bad news deal right there. So you may want to consider having a trust anyway for them, just to help have someone else manage their money. But if they're actually getting benefits from one of these need-based programs or can get benefits in the future, leaving them money will disqualify them immediately or could disqualify them in the future. So a common special needs trust will have restrictions so that the trustee, the person you appoint to manage their share of the money that they receive from you, will actually be managed in a manner that they will not disqualify them now or in the future. So the long answer, but the idea is it's twofold. Number one, they may need help managing their money, so that's kind of the obvious. And then number two, you may not want to let them lose their benefits or not qualify for benefits in the future.
Okay. Another great question for you. What are some of the complications for couples that have foreign real estate? So they own property outside of the United States of America.
Yeah, good question. So fortunately, most of the countries where most of our U.S. citizens visit or have real estate recognize trusts. Trusts have actually been around for a long, long time. They were originated in England, several hundred years ago. And so very commonly what we'll see is where somebody will associate or work with an attorney in that jurisdiction to use a revocable living trust here that will own their property there. Now, if somebody does not have a revocable living trust, then they're going to be subject to whatever the probate laws are in that other country in order to get their property transferred to their family members or heirs after they're deceased. So that's one where, I just had a client in last week who has some property in Canada. She doesn't own it yet. Her dad owns it, but they believe it's already in a trust and is already written up so that she could inherit it without going through a court process in Canada. But if somebody has property and they own it in their own name, then they certainly should consider a revocable living trust to avoid any legal hassles in that country, and we would associate with an outside attorney.
John, we're almost out of time. I've got one more question for you. With the estate tax in Washington State in the lower $2 million threshold, how realistic is it if people, let's say one person in a married couple, one person dies, can the other spouse just plan to take up residency in a state that doesn't have an estate tax to avoid Washington State's estate tax and then die in a different state?
Yes, they certainly could. That's one alternative. And there are other workarounds, as we call them. Certainly could move to another state. It becomes more problematic when they have real estate here, because if they own a lot of real estate and that makes up the lion's share of their wealth, then that real estate will be subject to Washington State estate tax. So, but if they've got liquidity, if they divest themselves of real estate and move to, say, Arizona or somewhere like that, then yes, they will be subject once they become residents. And usually most of those states, once you've lived there 6 to 9 months and make it a permanent sort of place, and you get a license and you register your car, et cetera, then you can kind of qualify as a resident. Again, as long as you've divested yourself of your Washington real estate.
Okay. Well, very good. I know that our listeners are going to get a lot of value out of this. I just want to remind the folks that are on the program today, I went ahead and recorded this program so that we would have it archived. If you know of anybody that wasn't able to be here today, but you think that they might receive value from this, send me an email, jason@parker-financial.net, jason@parker-financial.net, or call us at 360-337-2701. Let us know that you'd like to get a copy of the replay, and we'll post it and we'll send you an email when it's available so that you can share it with a friend or help spread the word. John, I just want to say thanks again. I know that the work you do is really important. It has a significant impact in people's lives. People are a little bit scared sometimes. You know, I'm reminded my grandmother, she refused to get her estate documents done. She said her thinking was that if she ever got her estate documents done that she was going to die. So she put off getting her will until the very end of her life. She was actually laying on her deathbed in the hospital. So you know, in some ways she was actually right. She got her estate documents done and then ended up dying. So
I just want to mention too that my contact information is on the screen, but when I did this slide, I was in a transitional period and the email address is actually incorrect, and I didn't catch that today. It's actually John K at kennylawfirm.com. It's a little different than what's on the screen there, but anybody can call or email or just get in touch with us to ask questions or schedule a consultation if they wish.
Okay, very good, folks. Thanks for being here. And John, thank you.
You're welcome. Thank you, Jason.
Take care.